Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-decision episode of SCOTUScast, Governmental or Commercial Negligence Edition. I'm your host, Bridget Flaherty. On April 29, 2019, the Supreme Court decided Thacker v. Tennessee Valley Authority, a case involving a dispute over the discretionary function exception to waivers of federal sovereign immunity. In 2013, Anthony Szozda and Gary and Venida Thacker were participating in a fishing tournament on the Tennessee River. The Tennessee Valley Authority, TVA, had a crew near the river trying to raise a downed power line that had partially fallen into the river instead of crossing over it. The crew attempted to lift the conductor out of the water, concurrent with Szozda and the Thackers passing through the river at a high rate of speed. The conductor struck both Thacker and Szozda, causing serious injury to Gary Thacker and killing Szozda. The Thackers sued TVA for negligence. The district court dismissed their complaint for lack of subject matter jurisdiction. On appeal, the U.S. Court of Appeals for the 11th Circuit affirmed that judgment. Although the act creating the TVA waives sovereign immunity from tort suits, the court held that the waiver does not apply when the TVA was engaged in governmental functions that were discretionary in nature. Applying a test derived from the Federal Tort Claims Act, the court determined that the TVA's challenged conduct fell within this discretionary function exception, and immunity therefore applied. The Supreme Court unanimously reversed the judgment of the 11th Circuit and remanded the case for further proceedings. In an opinion delivered by Justice Kagan, the court held that the TVA's sue and be sued clause, which waives sovereign immunity, is not subject to a discretionary function exception. Rather, on remand, the court below should consider whether the conduct alleged to be negligent is governmental or commercial in nature. If it is commercial, immunity does not apply. If it is governmental, immunity may apply, but only if prohibiting the kind of suit in question is necessary to avoid grave interference with the governmental function at issue. And now, to discuss the case, we have Richard Peltzsteel, professor at the University of Massachusetts School of Law.
Justice Kagan authored the opinion of the court in Thacker v. Tennessee Valley Authority, published on April 29 on certiorari to the 11th Circuit. Thacker was about Gary Thacker, a fisherman in a tournament who in his boat at high speed struck a downed power line. Workers for the Tennessee Valley Authority were trying to raise the line from the water. Thacker's passenger was killed and he was injured. Thacker sued the TVA in negligence for how it was raising the line and the adequacy of its emergency response. The Tennessee Valley Authority was created, as the court described it, in the throes of the Great Depression to bring economic development to the Tennessee Valley region. The TVA is a wholly owned government corporation, what today's global parlance calls a state-owned enterprise. A big part of its work is in power generation, including hydroelectrics. It has 60 power plants of various kinds providing power to 9 million people in 7 states, and with $10 billion in annual revenues, it does not require congressional appropriation. Under the TVA Act of 1933, the TVA can sue and be sued. That's in 16 U.S.C. Section 831C sub B, and is typical of New Deal-era government creations that were supposed to act like market actors and stimulate the economy out of depression. That broad exposure to suit is still limited by implication by the separation of powers. Under a 1940 case FHA versus Burr, suits that would gravely interfere with a government function still aren't allowed. In 1946, the Federal Tort Claims Act waived sovereign immunity for government agencies, subject to an exception for discretionary functions, or discretionary function immunity. But on its own terms, the FTCA excluded the TVA. Despite the sue and be sued language, and despite its exclusion from the FTCA, so exclusion from discretionary function immunity, the lower courts let the TVA off the hook in Thacker's suit precisely on grounds of discretionary function, holding that the FTCA discretionary function concept was equivalent to the separation of powers idea from earlier case law. In other words, the FTCA merely codified the earlier concept. On April 29, the Supreme Court unanimously reversed and remanded. The lower courts had erred in applying the FTCA's version of discretionary function, which is much more generous to state actors than Burr's separation of powers floor. The lower courts improperly ignored the plain language of the FTCA and its exclusion of the TVA. The sue and be sued language strips the TVA of immunity for commercial functions, the court held. When the TVA acts as a commercial actor, such as when it sells electricity, then it's vulnerable to suit like any other actor in the marketplace. In contrast, despite the sue and be sued language, TVA may invoke sovereign immunity when it acts as a sovereign, that is, in a governmental capacity. For example, TVA has the power of eminent domain, and it has law enforcement officers who investigate crimes and make arrests. However, when TVA claims sovereign immunity, its protection is thin because of the sue and be sued clause, which the court reaffirmed should be liberally construed. This thin remaining sovereign immunity is an implied exception to the TVA Act, outside its plain language. The proper inquiry to define this immunity is the pre-FTCA test from FHA v. Burr. In Burr, the court held Congress would not have intended to authorize suit when it could be clearly shown, either first, the type of suit at issue is not consistent with the statutory or constitutional scheme, or second, restriction is necessary to avoid grave interference with the performance of a governmental function. TVA's sovereign immunity then is grounded in separation of powers and only pertains as relevant here when a suit threatens grave interference with a governmental function. That is, it would pit the judiciary against the executive. In Thacker, the Northern District of Alabama had held that the TVA exercised discretion in how it raised a down power line, so the conduct was covered by immunity, and the 11th Circuit affirmed. To be frank, that ruling always was debatable. Even under the FTCA, discretionary function is not a blanket immunity for any choice government makes. Its purpose is consonant with separation of powers, protecting executive entities to have some latitude in making and implementing policy. But policy is key. Otherwise, discretionary function would swallow every negligence claim under the FTCA. A negligence claim, after all, says defendant did something a reasonable person would not have done, or failed to do something the reasonable person would have done. In other words, the governmental defendant and the reasonable person made different choices. Pulling a downed power line from the water at first blush seems a ministerial function devoid of policy implications, but the TVA had persuaded the lower courts that its choices did arise from policy of the sort Congress did not mean to subject to adjudication under FTCA negligence actions. The government in Thacker, on appeal, asserted that it could meet even the Burr test, but the court was quick to observe that the lower courts had never applied Burr. The government asserted that a negligence suit would subject the TVA to judicial second-guessing, but no, it would not, the court concluded. As the court characterized the government's position, the TVA would have the court let the FTCA in through the back door when Congress has locked the front one. That argument has failed before, the court observed. In FDIC versus Meyer in 1994, the court refused to immunize the then Federal Savings and Loan Insurance Corporation under a theory grounded in FTCA exception. Congress did not at all intend for sue and be sued entities to have immunity coextensive with FTCA defendants, the court ruled. Moreover, the court accused the government of overplaying its hand by claiming that all suits over exercise of discretion implicate interference with governmental functions. Not so, the court reasoned, when the defendant is acting like a commercial entity. The court previously has held that liability exposure of the sue and be sued U.S. Postal Service should be similar to that of other self-sustaining commercial ventures. Thus, the governmental-commercial distinction comes into play before the Burr immunity question. Only upon finding governmental function is the Burr analysis triggered. Now the case will have to go back to the district court, where the TVA's burden might be prohibitive if it doesn't settle. If claiming policy discretion was a tough showing the first time around, TVA now has to establish it's been sued for governmental rather than commercial function, and then that the suit would gravely interfere with the performance of that governmental function. Any electricity provider with lines running over water would have to lift those lines from the water when they fall and secure the waterway. As the court focused so heavily on TVA's likeness to other commercial actors, it's going to be difficult for TVA to get its governmental approach over both hurdles. For SCOTUS blog, Gary Thacker observed that the court's adherence to the text of the TVA Act draws into question other lines of federal case law in which the courts have borrowed FTCA discretionary function immunity. Some decisions have carved out discretionary function immunity for sue and be sued entities like TVA, and those precedents are clearly mistaken now under Thacker. According to SCOTUScast, every court to consider the question has found a discretionary function immunity in the Suits and Admiralty Act, which waives sovereign immunity from maritime claims against the federal government. SCOTUScast cited a Fourth Circuit dissent in which Justice Michael Luttig called his court out for mistakenly equating implied separation of powers with statutory discretionary function immunity. The court's reliance on the commercial governmental distinction in Thacker is interesting because that dichotomy was something advocates for both parties struggled to avoid in oral argument in the case. The TVA knew that it would be disadvantaged by losing immunity claims for all functions that could be characterized as commercial, and counsel for the plaintiff wanted the court to hang its hat on the broad sue and be sued language of the statute, not wanting to risk that TVA could continue its winning streak upon implied exceptions to the rule. Nevertheless, justices from both sides of the ideological spectrum in oral argument kept returning to the commercial governmental distinction. In the end, that became the first step of the analysis for litigation against sue and be sued entities such as TVA, and given the court's narrow construction of the Burr exception on the second step, this case goes into the books in the win column, both for textualist statutory interpretation and for the plaintiff's bar.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.